What should you never, ever, ever do in an estate planning practice if you want to have a viable business that meets the needs of your clients? What policies need to be in place to eliminate time wasters? How do you screen in good clients but keep the bad ones out? And what's the one big thing that can turn a prospective client into a walkout about half of the time? I'm Jeffrey G. Mersacci, an attorney, author, and member of the Estate Planning Sources Attorney Council, known as the Plain English Attorney. And I will review my list of 10 deadly sins in an estate practice and client process that saves me from wasted time, colossal frustration, while helping me get the clients I enjoy working with, all while providing my clients an exceptional experience and top-notch estate plans. This presentation is being created for a webinar for the Estate Planning Source to air on June 17th, 2025 at 11 a.m. Mountain Time, and that's 1 p.m. Eastern Time. For my clients, audience, and the general public, I'm going to give you 3 of these 10 deadly sins, but you have to go to the Estate Planning Source's YouTube channel to watch it live or get the replay after June 17th. Don't worry, I'll make sure that the one big thing is included as part of the 3 being released early on my channel. So, the 10 deadly estate practice sins. What are we never, ever, ever going to do? We're never not going to have an estate planning process, not have our staff well-versed on it. And also, if there are other professionals involved in the process, they need to also be on board and understand it, and maybe even we're negotiating it. As an example, with the Estate Planning Source, there's one particular advisor. We do a lot of work together, and for them, we know that there's a process. Here's what happens first. Here's what happens second. Here's what happens third, and here's who's assigned to each of these tasks. What happens in between each of these meetings with the client, which may be ones that I do or ones that they do. All of this is laid out, and we all know what page we're on, and our staffs understand what's going on. I've also got some written procedures on how to do this that we work together on. So there may be a different process for what you want to do. If you're an estate planner, whether it's a law firm or an advisor or an accountant or some other type of professional, you just need to make sure that every step of that process is laid out, becomes a standard operating procedure. That's just the big thing. All right, so let me talk just a little bit about the client process, and I'm going to pull it up, and I'm going to keep this super quick. In the estate planning process, I realize that there's an awful lot of information. There's homework that has to be done on the part of the clients. And the way a lot of attorneys do things, it's like, okay, you gave me the information. I'm going to put together the documents and I'm going to send it to you. Here's 200 pages of stuff to look through. Just let me know if you got any questions. If it's ready, we'll just go ahead and sign it. Oh my gosh. It's so much overload for so many people that they just can't get to it. It's too confusing because, well, wait, this says one thing in one place, it says another thing in another, and they don't get an overview. So what we have is the estate strategy session where we get the answer to the big 4 questions, keep it simple, make sure we're getting the feedback and the information on who they want to do certain things, and then how is the estate allocated and distributed, and put in several layers of contingencies, talk about age limits and things like that. All right, we do that at the strategy session. Next step is the estate summary. We're not going to just send them all of these documents and say, here, read through it. Again, information overload. The estate summary, we walk through section by section. Usually it's only about 10 to 20 pages. And I spend a lot of time covering, here's what the different documents are, here's what they do, and walk through it. And then here's what all the names under the different positions are. Here's the flow of the estate. Here's what happens if this person passes on. Here's the age limits, and it's all walk through. All right. Now we're going to send them the documents and have a document review meeting. And suddenly things are so much easier because they've had that intermediate step of the estate summary to go through, that it becomes a lot easier to go through the documents in whatever depth they're comfortable with. Great. Usually, about 80% of the time, that meeting becomes, all right, I read it, Jeff. There's a lot of legalese. I've just got one or two questions or maybe a change or two, and we go from there. The other 20% of the time, well, there's a reason why we schedule all of our appointments in 1.5 hour increments just in case. They walk in with 10 pages of notes. What's this Texas and Florida homestead exemption? Can you explain the generation skipping tax? Go over again what's the difference between the A, the B, and the C part of the trust. It's like, all right, look, we'll go through it. The objective is to make sure that at that point, everything has, all the questions are answered, everything is updated with any potential changes, and it's done. So then we can go to the next phase, which is signing everything. So we get the documents put together through the estate planning source. It's ordered, it comes in, set the signing. That's all we're doing on that day, is signing everything. That's it. Well, why do we do it that way? Why can't we then just proceed to the next step and talk about funding? Look, I've been doing this long enough to realize that even though it may only be half an hour of time for signing everything, everybody is mentally drained. And nothing that we say sticks. And then the next meeting just ends up being having to recap everything that we did at the end of the last meeting rather than actually going on to the next phase, which is the funding meeting. We keep it all in that process so that signing is separate from the funding meeting. I think it's important enough to make sure that we have that full amount of time to talk about all the different assets and what they do. So we have our clients fill out that confidential financial analysis form ahead of time, go account by account, asset by asset, discuss what's the best way to make sure that it gets working in conjunction with the trust and the overall estate plan. So that's the funding meeting. One of the things that we do, which I recommend taking a look at, we actually provide written instructions in the form of a spreadsheet. Transfer ownership of this account into the name of the trust specifically. And then I put, quote, there's the full name of the trust along with the date of it already in there. And I tell my clients, if you're going particularly to a bank, bring your trust, bring the recommendations, plop the whole thing down on their desk and go, here, this is what the attorney said to do. So it's nice and easy and smooth for the clients. And then there's a meeting after that I offer, and I wish more of my clients took me up on it. We call it a family review meeting. And that's where we can bring in whomever they want, walk through the different documents and what they do, and open it up for questions. Kind of like that same section in the estate summary where I walk through those different documents and talk about what they do. Now it's for the benefit of whomever they want to bring in. And I typically recommend, look, if we're going to do this, bring at least the first and the second successor trustee, since they're the ones who are going to have to grab the binder and start getting to work if anything happens to both of you. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. So that's the process. So we've kind of taken that interlude. Let's get back to the rest of it. Meeting with people without them doing their homework. For me, I mean, I know there are plenty of attorneys and advisors who are happy to talk with people for free. They consider it a valuable amount of time, but look, if they're not doing 3 specific things before they sit down and meet with me for a strategy session, then I know that the stats are there, that it's just wasting a lot of my time. First thing they have to do is they have to read whatever book is appropriate. And usually it's either estate planning basics for, hey, we need to do estate planning, or the long-term care solution if we're talking about potential long-term care and Medicaid planning, either of those. And they have specific questionnaires that need to be filled out and provided back to us before the meeting. So that's the second thing. And now the third thing, they have to actually come to my office and sit down so we can go through things. All right, so what are the stats on this? I mean, why would you do this? Well, look, I didn't used to require it. I used to just sit down with anybody who wanted to talk about estate planning. All right, so because I'm talking about avoiding probate, because I'm talking about concepts other than a last will and testament, which is what all the probate attorneys tell their clients. Oh yeah, just go ahead and do a last will and testament. Probate's no big deal because we know they're getting 4 to 10% of that estate on the back end by handling the paperwork that's not necessary. Well, when we've got a revocable living trust, we're trying to avoid probate. Here's the stats before. Almost universally, almost 100%. They needed a second meeting because we spent the first meeting talking about probate. Here's the difference between a will and a trust. Here's what probate actually is. And it was a completely foreign concept of a revocable living trust. Why isn't everybody doing this? I don't get it. Okay, fine. They got to come back a second time. Only 50% actually came back for that second meeting. And then 50% of them do something with us, but only half of the time they did a trust. And usually it was, well, I don't fully understand this trust, so I'm just going to do what everybody else does, which is a will. So for every 8 1.5-hour meetings, we would get a trust. Plus 4 1.5-hour meetings. Okay, now it's 50% after we've instituted those. We need those 3 things. 50% cancel up front. But look, that's fine because they want to go with what's cheapest and what's simplest. And they may go with an attorney to do a will. Sometimes they come back to us, but okay. When they get into my conference room, 85 to 90% are doing something and signing up right there after that first meeting, right there at that first meeting at the end of it. 90% of that time, it's a trust. And it's because they've read through the book. They understand the difference between a will and a trust. And we spent that first meeting focusing on their goals and what they want to accomplish and getting the answers to the big 4 questions about who's doing what and how the estate goes. It's a lot easier. It wastes a lot less time. I almost fired an employee who wanted us to switch back to the old way of doing things. No. All right. So yeah, we want people to do their homework, but there's a reason behind it. And so that's a way that we screen out the clients that aren't really serious, but we're screening in the clients who really are, that we can spend a lot more time working with and help them. So I recommend you as attorneys and advisors, if you're watching this as an attorney or advisor, make sure that you've got your own kind of screening process before meeting with people. And you're probably going to save a lot more time and provide a lot more education to your clients and make your meetings a lot more productive. All right. So now this is the big one. I am not going to give out prices ahead of time over the phone unless you just want to be a document salesperson, then you're not going to give out prices because look, it's not just about selling a document. It's about doing a plan. What I usually tell people is, look, if you need to have your appendix taken out, go to a doctor. What do you need that for? Just go on Amazon and you can buy a scalpel. Do it yourself. It's all about the scalpel, right? No. Look, your estate planning documents are a tool in putting together the estate plan. That's what the attorney and the advisor is there.
In addition to not being a document salesperson, the fact is a lot of times when people are approaching estate planning for the very first time, they really don't know what they need or what the best plan for them is. And that's part of our job as professionals, as estate planners, to make sure that our clients are getting the exact type of package that they need. And it's not just as simple as, oh, are you doing a will or are you doing a trust? In some cases, a complication or another factor may enter into it that really has a couple of things that need to be added to the plan. All right. So just for example, it's very common, and these are the packages. All right, we could do a simple will plan for our clients, and it's a simple will: healthcare power of attorney, durable general power of attorney, nomination and conservator living will. If they've got young kids, appointment or nomination of a guardian, fine. That's one price. Second, we have the trust plan. So yes, avoiding probate is important, and they want to make sure they're doing it the right way. So we're doing a revocable living trust as the core of that plan. And I'll have all those ancillary documents that go along with it. That's the most popular for what my clients mainly need. But then we sometimes get to what I call the trust plus to the kids. What I say to the clients is this is in-law protection planning. All right, this is where you have a son-in-law or a daughter-in-law and you absolutely positively do not want them to have any access to your inheritance, to the point where you don't even want your child, if you pass on, to be able to take that and then leave it to the spouse in their estate plan. You hate this daughter-in-law or son-in-law so much that you want to make sure they never get a penny of your money, which, okay, great. We're setting up asset management trusts for the kids for the money to filter in. We're also doing IRA trusts so that the IRAs go in IRA trust, get the full stretch, but protect the money, and then 10 years later can combine with the asset management trust. So now for that whole children's lifetime, that money is held by a trustee and then has to go to the grandkids after. Okay, fantastic. That's definitely a different price. And then we sometimes, only occasionally, we get the full bloom. We need irrevocable trusts. We need lawsuit protection. And okay, we've got package prices for all of that. Occasionally it's like, well, okay, we've got one special needs child out of 3. They're adults. We need to protect their benefits. And the grandparents are leaving something to them. Oh, okay. That particular child may just get an IRA trust added on to make sure their assets are protected, and then 10 years later can get combined with whatever share you're leaving them in the revocable trust. The grandparents have that trust now for a special needs trust to drop that money into. So there's just a couple of additions. You don't get that over the phone. You have to sit down with your clients and understand exactly what they need, what goals they have, and then what tools are needed for you to put together the plan. Now, here's what happens. And this was at least half the time when my staff, against my instructions, just, okay, fine, you're beating me up so much about the prices. Here's what the different packages are. Here's what it costs for will. Here's what it costs for trust. Here's what the trust plus costs. We sit down, they need more than the trust plan. They need a little bit more. The only number they remember is what was for a simple will. So they quoted that package. 50% of the time, the clients would just get so upset. They're not going to do anything. But you said it was only going to be this, or your staff said it was only going to be this. It's like walking onto a car lot and saying, what's the least expensive car you've got on the lot? And well, we've got this 1996 Honda Accord with 300,000 miles on it. And on the top end, we've got this brand new Mercedes convertible for 175,000. The Honda Accord's only 1,000. They're going to want the Mercedes for the 1,000, 50% of the time. So that's why we just don't do it. Until we know exactly what's going to be the best plan, we can't quote a price. But the way we do it is we do have, after that strategy session, we do have a flat rate price that we give to the clients. So, and the way I explain this to my clients is, yeah, we're giving you a flat rate so that we're not charging you by the hour, so that you will feel free to ask as many questions as you want. So this is another thing that I've seen when you charge by the hour. A lot of time clients have questions, but they don't want to ask them because it's adding to the bill. And so you could give them the best estate plan in the world for them, but they're still going to be upset because they don't understand it. So that's why some cases we spend a lot more time. Sometimes it's a lot less and a lot easier. But with that flat rate pricing, it averages out. But we do not give those prices over the phone.
All right. So I hope you found all of that information useful. Like I said, this is going up on my YouTube channel. You're going to get only 3 of the 10. Make sure you go over to the Estate Planning Sources YouTube channel for either the live stream on June 17th or to get the replay to get the other ones. So like I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.